Idaho's library law, the keeping harmful materials from minors law, is getting its second legal challenge. House Bill 710 was passed in 2024, and it went into effect last July. The purpose was to keep certain books out of the kids section of the library. Those things the law deems harmful, anything obscene, what it defines as sexual, any sexual conduct, or any act of homosexuality. Even before the law was signed by the governor, the blowback began in local libraries, from the Nampa School District removing 22 books forever back in 2022, to the Eagle Library relocating nearly 24 last September, and then Kootenai County's library system just removing 140 titles to be reviewed just last month. Other libraries, like Idaho Falls, they made entire sections accessible to kids only when accompanied by an adult. Even further, the Donnelly Library, who made their whole one-room building adults only. So there was a lawsuit filed shortly after that law went into effect last July, because the law also applied to private school libraries, and that threatened their and their parents' independence and, of course, their First Amendment rights, they said. The lawsuit filed today widens that net a bit to include public libraries, but the claims remain the same. Idaho's library law violates the First and 14th Amendments, they say. The plaintiffs this time, that'd be book publishers, authors, a couple of students, and the Donnelly Public Library. You might remember we spoke with the library director last May when they decided their only recourse, because they only have 1,024 square feet to work with, was to make the entire library adults only.
I don't have an extra room. I don't have a place to put it. And those children deserve to have literature that reflects them.
Okay, so now that law has been in effect for 8 months, and attorneys for the plaintiffs feel they now have enough evidence to show that the law is harmful and infringing on the right to free speech and access to books. For example, the 2 high school students who joined the lawsuit say they can't get the books they need and want in their school libraries. J.E. is a 17-year-old student in Lewiston. She's taking dual credit courses through Lewis Clark State College. But House Bill 710 treats her much like a much younger child. The same school district that allows me to voluntarily engage with materials that are eligible for both high school and college credit hypocritically has the authority to limit my voluntary access to books that are appropriate for me in my own school library. Another student from Rocky Mountain High School in Meridian also happens to be 18 years old. House Bill 710 undermines my personal and academic growth, she said. It obstructs my access to the marketplace of ideas and critical information on topics like science, history, and politics. Information vital to my participation in a robust democratic society. Okay, so now the damages are not hypothetical anymore, much like with the Donnelly Public Library. Library Director Sherry Sheline looked at the circulation numbers for the 3 months after they went adult only and compared them to years prior. She said they dropped by 44%. 44%, we were told. And it's not just in books, because they do a lot more at the Donnelly Library, like they feed hungry kids. But she said people just stopped coming.
I think a lot of our families that had before, they just don't understand the nuances of it either. And so I think that they maybe stayed away from the library for reasons that they just don't understand. Because the words adult only are always just thrown around, and they don't want their kids in an adult only place, but yet we're still welcoming to children. And I think that scared people off. Our mission has always remained the same. We want to be a place of education. We love children. We want to be that anchor community in our town. But I do think it scared people off.
Well, so I can assume that's why you wanted to join this lawsuit, so you can take that off your library.
Yeah, I feel like gross legislation is disproportionately impacting small and rural libraries. Censorship legislation in any capacity is presented to small and rural libraries. It's really hard for us. It's hard for us to interpret the law because we're not lawyers, nor do we have a lawyer on retainer. For us, joining the lawsuit is really, we just want to do the right thing. And the right thing is that censorship is the greatest threat to democracy. And we have to fight that. We have to protect the books. We cannot protect the children if we don't protect the books.
Sherry told us their entire budget is $75,000, and if they had to set aside a retainer for a lawyer, should someone claim that they had harmful materials in their building, that would take about 10% of their budget. This lawsuit claims the library law not only violates the First and 14th Amendments, but it doesn't consider the merit of the material. It's too vague and it's too broad because it's difficult for libraries to determine what complies with the law. And it doesn't distinguish by age or grade level, as you heard from those students. Just because it's too much for a 10-year-old, does that make it too much for a 17-year-old? That's the kind of question these attorneys and this lawsuit is trying to solve. Sherry and her attorneys would like to see the library law scrapped entirely, but short of that, she just wishes legislators would more closely consider the impact of their laws on smaller communities. While enforcement of this law is the responsibility of private citizens, Idaho's Attorney General, several county prosecutors, and the city of Eagle are named as defendants because, well, they can ultimately bring a cause of action against the library. Attorney General Raul Labrador's office said they don't comment on pending litigation.